And this issue, unlike many issues, this issue has no place with race, no place with economics, no place with politics. This is an issue of right versus wrong. Milwaukee has its issues. I can assure you, it has its issues. But this shouldn't be one of them. We heard earlier the numbers. The numbers are real. We spend a lot of money in Milwaukee for a lot of stuff. And if there are any investors or economic majors out there, then you understand that return on investment is one of those things that you look for. Our return on investment is probably 0.01% if it's in the positive. But here's one thing that I found talking to a lot of different people in the city of Milwaukee, a lot of professionals, a lot of academics, is that fatherhood in and of itself, the absence of fathers in the city of Milwaukee, and recognize when I talk about the city of Milwaukee, I'm just talking about a microcosm of the bigger issue. The fatherhood absence in the city of Milwaukee has grown to pandemic proportions. So when we talk about high school dropout rates, teen pregnancy rates, sexual deviancy, juvenile delinquency, all of these things can be associated, connected to the absence of a father. And there is a mechanism in place that can control that. Now some would say, well, you can't make a father be a father, but you can. Because the courts can make a man who stole a candy bar out of a store wear a sandwich board on the sidewalk in front of the store that he victimized, but you can tell me that the courts can't make a father be a father. We're saying, if you're gonna make me pay child support, then make me be there for my child and hold everybody accountable for my behavior. Next up, we have a young man. I had the fortunate opportunity of speaking with him the other day, and he has a hell of a story to tell. It's all true. Everything that you heard up here today are real life experiences. And like how I talk about Milwaukee being the microcosm, every person that you see before you today is a microcosm of the significance of this issue. So every one man represents probably 1,000 men that are going through this. Because I'm sure we can call on many people in this ground today to speak something in regards to their situation, and we could be here all day doing that. But we selected a select few. And so right now we're gonna bring to the stage, bring to the mic, Mr. Eric from Milwaukee. He's had his kids sent to live with their mom, his daughter sent to live with her mom in Texas. And so we'll let Mr. share his story.
Thank you very much. I appreciate being here. This is me, and this is my daughter, Nikayla, also known as Kayla. Hello and good afternoon, everyone. My name is and once again, I am honored to be here speaking in front of you today. Not only is it an honor, but it's a privilege. Not for one second do I think that I'm the most deserving father here in attendance. Since going public, I've met several fathers who have been kept from having meaningful relationships with their children for years. I met one father who struggled for 6 years to see his children. I've met fathers who have horror stories that pale in comparison to my story. To those fathers, I say, stand strong. I say, continue to struggle. You have my full support, and I truly understand how it feels to be let down by a system. A system whose goal should be the reunification of the family and not the dissolution. A system that far too often leaves fathers disenfranchised, discouraged, demeaned, and in most cases without equal consideration, equal time, and equal access to their children. I would like to take the opportunity to thank dads of Wisconsin for allowing me the opportunity to speak today and share my story. I would like to thank my son, who is here with me today, his lovely girlfriend. Happy birthday, by the way. One of my greatest joys as a father has been watching my son grow up and mature into a fine young man. Words cannot express how proud I am. I want to thank everyone back at home in Milwaukee for their kind words and support. I want to thank, actually a special thanks to Sam Caban. He's been an unwavering friend and documenting my unknown struggle to be reunited with my daughter. If my daughter has an opportunity to see this, I want to say I miss you and I love you. I look forward to your return, and I will not stop fighting until you are safely home with your father. My daughter was born in 2001. I had joint custody since paternity was established in 2001. In 2004, the mother stipulated a motion granting me physical placement. A stipulation means she basically agreed that you take care of your daughter. So I had primary placement. She lived with me. I was her primary caregiver since 2004. Facts of the case. I'll try to breeze through this really quick. Around November 2009, a stipulation that amended my original stipulation for primary placement of my daughter was filed with Children's Court that left the mother with supervised visitation. The stipulation was based on a CHIPS petition that removed my daughter and her two siblings from her mother's care. The CHIPS petition alleged child abuse, including beating naked children with extension cords, locking children in their room until they had to urinate out the window, multiple acts of hitting the children with belt buckles. The children were subsequently returned to the mother after completion of court-ordered services. In other words, she entered into a deferred prosecution agreement, she completed that, and the charges were dropped. On or about October 12, 2012, the mother of my daughter abandoned my daughter in my care. They don't like to use the word abandonment in court. I don't know what else to call it. She showed up at my daughter's school. She told her goodbye, and about 2 or 3 days later, she relocated to Texas. How did I find out about this? The school called me because my daughter was upset. They asked me, did I know that my daughter's mother was moving to Texas, and pulled my daughter out of school to share this information with her. That was the first time I heard this information, and that was from the school officials. I have a letter here documenting that event. Due to the mother's sudden move to Texas, I filed a motion to change legal custody and child support. The matter went before the court commissioner. It resulted in an increase of child support paid to me by the mother and the appointment of the guardian ad litem. I filed a motion, subpoena, duces, tecum, with the judge. In this motion, I asked to release certain documents relating to the mental health of the mother pertaining to actions I had personally witnessed. I won't go into detail of those, but I thought it relevant. When people abuse children, these type of issues should be taken seriously, and they merit further investigation. That did not happen. On July 18, 2013, the matter went before Commissioner Barrios. Barrios denied the mother's motion for overnight placement, but she did allow for limited placement. This matter was set to be heard before Judge White. Thinking this was an open and shut matter, I went before Judge White, pro se. At that hearing, I was not allowed to present my case. I was told multiple times to be quiet and stop talking. I was insulted, and I was talked to in a very derogatory manner. It was as if my presence was just not wanted there. My voice was just not wanting to be heard. I was not allowed to address the issues of the child abuse. I was not allowed to show the documentation. I was not allowed to talk about the abandonment at all. The guardian ad litem was allowed to talk at length about issues that had nothing to pertain with anything. For example, she wanted to mention my daughter's menstrual cycle. I don't know what that had to do with why we were there, but it just kind of goes to show the level of detachment of the courts and the jails. this hearing, the guardian ad litem asked that my daughter be placed in Texas for a visit. I object to this. My objection was overruled. I objected for several reasons. There was no investigation into the home of the mother in Texas. In other words, they had no idea where they were sending this child. At the time, I believe she was 12. They wanted her to get on a plane, fly to Texas, unsupervised, and reside with her mother for an extended period of time. I found that to be fundamentally flawed. As her father, at that time, I hired an attorney who filed a motion for reconsideration. This particular judge sat on this motion for reconsideration for a period of several months. She sat on this motion until days before they were scheduled to send my daughter to Texas for a visit. When I inquired about the cost involved of all this, I was told that if I can't afford it, that they'll just leave my daughter in Texas. I found that bewildering, I found that insulting, and I was just amazed that, and that came from the guardian ad litem. Her position is, and always has been, to remove my daughter, who I've had in my care since 2004, and place her with the mother. For her, the issues of child abuse and neglect are not an issue. She will not hear these issues, she will not discuss these issues. I've been forbidden by the judge to show the documentation of the abuse. I think it amounts to a gag order. So I can't show it, but it's here, I have it. I struggle back and forth, of whether people need to see this information because the abuse is heinous, and as it happened to my daughter, I take it quite personally. This matter was set for trial on February 26th. On February 26th, I did not get a trial. On February 26th, the judge granted the mother sole custody and sole placement. The judge ordered me to hand over my daughter that day. They ripped her out of school, they ripped her out of my home, and sent her to Texas. My daughter was a great student. She got A's, she has B's. I have her report card. I have a letter from the school documenting how well-adjusted she was, talking about her peers, talking about her friends. My attorney filed another motion for reconsideration. The judge denied this motion. In other words, the judge says, I don't want to hear this matter. We're going to take your daughter, we're going to send her to Texas, and you can come back in July 24th, 5 months. For 5 months, I've been without my daughter. I've not seen my daughter. Currently, I'm unaware of my daughter's exact location. The Legal Aid Society, the guardian ad litem, works for the Legal Aid Society, will not return my phone calls. As a matter of fact, they told me via my lawyer that they would prefer that I not contact them anymore. They want me to direct all my questions through my lawyer. My response was, I would prefer if you return my daughter to me immediately. Currently, Texas CPS is involved. There's a police report. I don't know what happened. I'm trying to find out what happened. All I know is on a Thursday evening, about midnight, I got multiple calls, multiple text messages from my daughter. She was crying, she was terrified. She was locked in a room. There was some type of violent confrontation going on in the home. And that was all the information I could get. We requested the guardian ad litem to get involved. She has not. It is my firm belief that by sending my daughter to a known child abuser constitutes gross negligence. There was no mechanism put in place in the interim between February 26th and when I go back to court in July for contact. They told me I could Skype my daughter. That's what they said. They also said I could get 3 phone calls a week. I have not been getting those 3 phone calls a week. And in the last couple of weeks, my daughter's phone has been disconnected. I have no communication. I would like everyone to please visit my website, www.BringKaylaHome.com. There's more information on that website. And if you can, just please share the word. And for fathers across Wisconsin, I believe that, things have to change. We need equal time with our children. We are just as important as the mothers. Thank you for your time.